Right, one of the first questions that a client normally asks whenever they come to see a lawyer is how much is it going to cost in order to contest a will? Now, that question is very, very difficult to answer at the very first meeting for a number of reasons. It all depends on how complex the case is, how much work needs to be undertaken, and what are the prospects in relation to doing matters. Now, I can only talk about what I can do. I can't talk about what other law firms do. But what I would say at the very first initial meeting with a client is I normally see them for about half an hour free of charge initially to give an overview to assess what the case is all about and how complex and how long it'll take to do. If it is a case that we need to write off and get some medical notes, if we need to get the previous solicitor's file of papers before being in a position to advise a client on what to do going forward, those type of costs normally come to about anywhere from £500 to £1,000 plus VAT. Now, having got that information, if the prospects of success are greater than 60%, I will then consider whether I can act on a no-win, no-fee basis, or as lawyers call them, conditional fee agreements. If we do act on those type of arrangements, what happens going forward is that you don't pay for our charges on an ongoing basis. However, if we are successful at the end of the case, you will then be responsible for our fees together with an uplift, which is normally anywhere from 10 to 20%. We will seek to recover those costs as much as possible from the opponent if successful. If not successful with the claim, then you will not pay any fees towards Wright Hassell's time in dealing with this matter. Now, overall, the average fees, if a claim does go all the way through to a final hearing, will be in the region of about £100,000 to £150,000 plus VAT. That being said, only 2 to 3% of cases get to that stage. The vast majority of matters either settle, and I think the stats say about 40 or 50% settle before proceedings are issued. And then the other points when they do settle is at the stage of exchanging witness statements or disclosure. At all times in relation to these type of matters, mediation should be considered right at the very beginning. Mediation prospects, it is something like 70 to 80% of cases settle at mediation. So certainly that should be considered at the first opportunity for all parties. And the mediators are highly skilled individuals. Their jobs are very much to bring parties together, to try and negotiate terms of settlement. And in order to get rid of this, because I'm sure the last thing you want to be doing is spending a lot of time talking to lawyers, waking up in the morning, thinking about your case, going to bed in the evening, thinking about your case, and it can take over your thought process for 12 to 18 months, which is the time it could take to go all the way through to final hearing. Next, in relation to what happens if you lose your case. Now, solicitors will give prospects of success at the beginning of a case, or should give prospects of success. If they are 60%, it is deemed to be a good case, 65% a very good case, and 70% an excellent case. There are no guarantees in litigation. A different judge can see a matter differently on the day, and therefore there is room, I'm afraid, that we can't guarantee successful outcomes with cases. Now, if that is the case, it is normally the position that the losing party ends up paying the winning party's costs. But what we will be advising at an early stage is to take out what we call after the event insurance. That means if you go all the way through to a final hearing and you're being represented on a no-win, no-fee basis, if you were to lose, the after the event insurance would pay the other side's costs and not yourself. So that is something that we do need to advise right at the very beginning so that you fully understand everything. That's if we act on your behalf on a no-win, no-fee basis. If, and we do come across these type of cases, individuals come to us with prospects of 50% or less, and we can't act on a no-win, no-fee basis. It would be very much on a private fee-paying basis, ongoing as we go through the matter. And as I've mentioned beforehand, the cost for doing that can be 100 to 150,000 if it goes all the way through to a final hearing. And the normal rules apply. If you win your case, you're entitled to your reasonable costs from your opponent. But if you lose, you may well end up paying your own costs together with the opponent's costs. So taking all of that into account, right at the very beginning, right at the very first meeting you have with a solicitor, one of the first questions should be, how much will this cost? And what can you put in play to try and protect me as much as possible? That advice back to you should be extremely clear. It should be in black and white print, so you can spend time reviewing it. In relation to conditional fee agreements, any queries whatsoever, you should be raising them with your solicitor. I will continue with these little snippets, and the next one I'm going to do is how long it takes to progress a case through to either a successful mediated outcome or negotiations, or for it to go all the way through to a trial. Thank you.